Good morning. Today is Tuesday, May the 10th, 2016. It is 10 a.m. It is my pleasure to call to order the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Miss Lisa Mosby, would you please call the roll?
Dennis Bridges. Here. Mark Cawthorn.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Robert Helms.
Here.
David Neal.
Here.
Charles Rahm.
Here.
Mr. President, all board members are accounted for.
Thank you, Miss Mosby. Moving on to the agenda.
Motion to accept the agenda.
Second.
A motion by Mr. Helms, a second by Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries. Under the minutes. These are the minutes from April 12th, 2016. I ask for an approval of those.
Motion to accept.
Second.
A motion by Mr. Helms, a second by Mr. Rahm. All in favor say aye.
Aye.
Any opposed? Motion carries. Now to the legal report.
Morning, everyone. I'm Benjamin Glover, Assistant General Counsel. I'll be filling in for your normal board attorney. We've got, I believe, 7 cases to go through. If you have any questions, please just interrupt me and ask me. First case, 20160174441. Complainant is the mother of the deceased. The complainant states the respondent stated that due to the size of the deceased, an oversized casket and vault would have to be purchased, adding at least $2,500 to the bill, and they may need to purchase 2 lots at the cemetery. Complainant picked out a casket with crosses on the bottom quarters and "In God's Care" on the inside lid. Complainant signed the contract on December 23rd of 2015. Complainant was not pleased with the casketing of the decedent. The inside lid of the casket stated "Going Home" and not "In God's Care" as they had selected. Complainant states that the respondent attempted to rush them through the visitation, stating that they would be charged double for using the cemetery after hours. Complainant states at 2:45 p.m. the respondent turned people away and shut the doors even though there was a line outside. After the service, the respondent adjusted the decedent in the casket and removed part of the liner. The grave site, the pallbearers dropped the casket just as they got to the grave because the handles were coming off of the casket. The complainant provided an employee of the respondent with a list of concerns. Upon receiving a copy of the death certificate and signed contract, the complainant states there were many errors on the death certificate and the signed contract was not the contract the complainant had originally signed. The respondent told his employee that respondent signed complainant's name on the contract due to some changes the respondent had made, and the respondent did not think the complainant would mind. Complainant alleges that they were charged for an oversized casket but did not receive one. The respondent ordered the largest casket possible that would fit inside one grave space. Respondent stated that after getting all the figures compiled and entered into the system, the respondent realized the complainant had not signed the contract itself, and using the complainant's implied consent, the respondent signed it. The respondent explained that they had done the best they could do with regards to the preparation and casketing of the decedent. Respondent explained that the casket insert was an accident. Respondent states that he has never forced family to start a service and that the respondent never tried to hurry the family. Respondent stated that the complainant's husband stayed after the service because they needed his permission to remove portions of the casket in order to get it closed. There are 2 previous historical cases with regard to this particular respondent. The legal's recommendation is for the board to approve a consent order for $250 for signing the complainant's name to the Statement of Funeral Goods and Services without permission, and a letter of warning with regard to the unusual circumstances surrounding the case and potential authorization for a hearing.
Motion to accept the recommendation.
Second.
A motion by Mr. Rahm, a second by Mr. Helms. All in favor say aye. Any opposed? Motion carries.
Cases number 2, 3, and 4. Upon routine examination, it was discovered that the respondent funeral home was allowing an employee not licensed as a funeral director to discharge the duties of a funeral director. A cremation authorization bears the signature of an apprentice funeral director on a line designated for the funeral director. Respondent funeral home states that respondent was unaware that an apprentice funeral director could not sign the cremation authorization form even under the direct supervision of a licensed funeral director. Respondent funeral home failed to disclose that the price being charged to purchasers for the cash advance item shown on the statement of funeral goods and services selected as crematory fee is a higher price than the respondent pays the crematory for the cremation. According to statements provided during the inspection, the crematory charges the respondent $300 for cremation and the respondent charges $395, but fails to disclose in the area required and designated for such disclosure. Respondent states that receiving this complaint, respondent has acknowledged that all cash advance items that are marked up are disclosed to the consumers. Respondent funeral home utilizes two separate cremation authorization forms requiring authorized agents to sign two separate cremation authorization forms. Respondent funeral home states that though the authorized agent was required to sign both forms, but since having received this complaint, respondent only required the authorizing agent to sign the cremation authorization and disposition form. There's no historical complaints with these respondents. The recommendation is for case number 2, a consent order with a $750 civil penalty and authorization for a hearing. For cases number 3 and 4, a letter of warning regarding an apprentice signing documents that require the signature of a funeral director.
Motion to approve the recommendation.
Second.
Motion by Mr. Rom, a second by Mr. Bridges. All in favor say aye. Aye. Any opposed? Motion carries.
Cases number 5 and 6. Number 5 first. Complainant was a manager for the respondent establishment for a short period of time. Complainant filed the complaint to ensure that she completely removed herself from the respondent establishment, including stopping the trade embalming that she originally agreed to do for them. Complainant states that she had knowledge of decedents within the facility after it closed. Representatives from the legal department as well as the funeral board inspected the establishment on April 4th, 2016, and notified authorities that 2 decedents were left in the building upon closure. Complainant was angry that until the establishment owner named a new manager, the current manager's name could not be removed. Respondent is no longer operating an establishment and has submitted a letter stating such to the board office. Respondent did not respond to this complaint. Number 6, complainant states that respondent establishment has collected direct payments for grave spaces and burial vaults, but has not paid the vendors for these services. Respondent is no longer operating an establishment and has submitted a letter stating such to the board office. Respondent did not respond to this complaint either. There are 3 previous instances of disciplinary action. Legal's recommendation is to close the complaints and flag the owner in order to notify the board if he decides to open another establishment.
Motion to accept.
Second.
Motion by Mr. Helms, a second by Mr. Duffer. All in favor say aye. Aye. Any opposed? Motion carries.
Last case is a representation. At the March 8th, 2016 funeral board meeting, the board authorized a consent order and $250 civil penalty against funeral home for failure to respond to a complaint. Subsequently, the consent order was mailed out on March 30th, 2016. On April 4th, 2016, the respondent mailed the signed consent order and payment back to us, also sent proof of his response as well. Due to this time-stamped email showing where he did respond to the complaint on January 11th, 2016, we believe that no wrongdoing has occurred by the respondent. This case should be closed with no action.
Motion to accept.
Second.
Motion by Mr. Cochran, second by Mr. Davis. All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. On to the director's report, Mr. Robert Gribble.
Thank you, Mr. President. The first thing is the legislative update. Today we have the bill that passed and was signed by the governor on April 21, 2016. It's Public Chapter 838. It's effective July the 1st, 2016, and that was Senate Bill 2534 and House Bill 2569. It was an administration bill that affected several boards, but the part that affected the funeral board is it codifies and puts into statute what the board's longtime practice has been. If you have an associate's degree, then you only do 1 year of apprenticeship. It was in statute as far as the embalmer part, but the funeral director, it was not real clear in statute. So that's the only bill that passed that has a direct effect to this board. Now, there's some other bills that have indirect effect to funeral directors and to funeral homes and cemeteries, things of that nature, but as far as the Board of Funeral Directors and Embalmers, the legislative proposals for 2017. Board program is given the opportunity to submit a proposal or proposals to be included in an administration bill. I just kind of wanted to let you know, this is the email. If you go to over several pages there, you'll see an email from Ms. Rachel Powers, who is the Program and Policy Development Director for regulatory boards for us. And it's very hard to get a bill selected to be put in that because there's a lot of competition. There's 20-something boards, maybe 30-something boards, and each one of us are competing for it to meet the commissioner's approval. And then once if it does meet the commissioner's approval, then it also has to be approved by those in the governor's office. And some of the criteria was, does the proposal align with the governor's vision for the state? Does it help advance its priorities or make improvements in those areas? Is it good public policy? How does the proposal affect or interact with other suggested bills from other agencies? Does it cost the taxpayer money, or is there a fiscal impact? And is a change in law necessary to achieve the desired outcome? Some things can be achieved by rulemaking and not necessarily by statute. If the board has, and then on the second part you can see a document that we're required to complete in order to make that submission. If the board has a specific item or items that you would like for us to submit, we'll certainly be glad to get with legal. Have something you think is pressing, since we did have a bill that was in the we were included in the administration bill for something that affected the board last year. I would suggest that we wait, let some other people have their turn, but individually you may think of something or know something that you would like for us to submit, and we'll certainly be glad to do that. We're required to submit this internally by May the 20th, so we don't have too many more days. Have something that you want us to consider, if you have that, or do you want to send an email to me in the next 2 or 3 days? If you do, ever how you want to handle that, but I wanted to make you aware that there is an opportunity for the board to submit proposed law changes for it to be considered to be a part of the administration bill. However, at the same time, I wanted you to see what the criteria was and see what the process is, and to let you know that it's a very coveted position to be in a bill that's an administration bill. I'll go on and finish my report, and if you have something, if you want to come back to it, well, you can. The licensee report, this is a report of licenses administratively approved by the executive director pursuant to authority by the board for the period of April 12, 2016 through May 9, 2016, and you can see those establishments and individuals listed there. As far as a closed establishment report, there's one establishment that's reported closing since the last board meeting. That's Johnson's House of Atina, which is located at 1107 Buchanan Street here in Nashville. And the complaint First, the disciplinary action report. This is a report of consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of April 1, 2016 through April 30th, 2016. And those are listed. Complaint report. As of yesterday, May 9, 2016, there were 27 open complaints. One of those against an apprentice, one against a funeral director and embalmer, and 25 against establishment. President, I'll be glad to answer any questions you have. Otherwise, that concludes my report.
Does anyone have anything towards this legislative proposal? Okay, Mr. Gribble, I don't think we have anything at this time for the legislative proposal. Thank you for your report. Can I have an approval for his report?
So moved.
Motion by Mr. Rom,
Second.
second by Mr. Helms. All in favor say aye.
Aye.
Any opposed? Motion carries. Approval of license applications.
President, there are no individuals to come before the board today. There is one establishment, Sumner County Funeral and Cremation Services, LLC. The proposed manager would be Janice Faye Leonard. It'd be located at 128A West Eastland Street in Gallatin, 37066. It's a new establishment. Ownership's a limited liability company, and the owner is Sumner County Funeral and Cremation Services, LLC, located there in Gallatin. And in your application, you will see that there are 4 members of that LLC. And Leonard, if you want to come up and have a seat and make whatever opening remarks you want to the board, and I'm sure they'll probably have some questions for you. Mr. President, before she does that, one other thing, the parking authorization letter that's included in the iPad is not the latest one we have. They submitted an additional one this morning. The one that's in the iPad appears to be from a landlord, and we had informed them that we needed one from the city. So they have submitted to us a letter from the city of Gallatin, from the planning assistant there in the planning department, in reference to the parking.
All I have to say is I just appreciate you all giving us consideration. What we are doing this for is there's a lot of folks up in our area that cannot afford a traditional funeral, like what everybody thinks, $8,000–9,000. And at one of the funeral homes that I've worked at recently, we've had to turn families away because of the price. And so that's why that we're really, starting this up to do. There's not a service like this in Gallatin.
What will you do at your physical facility that we have pictures of?
What we'll do there is just make arrangements. We will have urns there. I am going to do caskets from a casket book, and I'm going to do vaults from the individual clerk examples.
Where we hold your visitations and services and so forth?
They will be held at churches or the people's homes or wherever that they choose. It will be nothing there. There's no embalming there, and there's no visitation or anything there.
President, there's one other thing I want to make the board aware of, too. I didn't think of this in the beginning. At one time, one of the members of this LLC worked as an employee for me several years ago when I was in private still practicing in the funeral service and owned the funeral establishment. But Mr. Gary Jones worked for me at one time, and I just want to make the board aware of that so that it's complete disclosure. I sold that business 14 years ago, and he didn't work for me he worked on a part-time basis probably for the last 2 or 3 years, but he's not a full-time employee for probably, I sold that business. But anyway, I just want to make the board aware of that.
On dressing and casketing, where will that take place at?
It'll take place, Gary will take care of that where their bond dad is over at Sadler Funeral Home.
Jones is a full-time employee of your funeral home, of this proposed new funeral home?
Gary, yes, he's a partner.
Okay.
Will Sadler Funeral Home, once they have the body dressed and casketed, will they just deliver it to the location where the visitation and service is?
Very well, yes.
Okay.
Question on the original application, it says amended application. Was there something added or missing or from the original?
I think that there was maybe some confusion on my part whether to put the LLC down or not to put it down. And maybe the 128 was listed as just 128 instead of 128A.
Managed a facility before, Ms.
I have.
Leonard? Okay. Your anticipated number of calls, I know we all like to be optimistic, but do you have an idea of how many?
I'd say probably maybe 50, 55, 60 calls a year. I hope it's 100. Don't know.
Foresee ever leaving this location, or you look to plan on staying at this location then?
Yes.
As far as your office is concerned, the application is complete and everything is in order?
Yes, sir. The only thing, Mr. Rahm, they've not provided us with any phone numbers or anything like that, but Ms. Leonard said that if the board approved it, that they would do that in the next couple of. That's just information we normally get that we don't have at this point. But as far as the documents to be submitted for your review, with that addition this morning, I think Mr. Duffer passed around, I gave to him and he passed down, that completes all the documents that needs to be for your consideration.
Motion to approve the application as submitted.
Second.
Motion by Mr. Rom, a second by Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Congratulations, ma'am.
Thank you.
Business.
President, I have one thing, if the board will consider it. It's a request. It's on your iPad if you want to look at it. It's a request from a funeral director regarding continuing education. I'll give you a second to look at that if that's
What's it under?
under. Seconds to read it, and then I'll speak to what the licensee has asked about. Give you a little bit of history. When I first came to this position, it was routine that there would be 5 or 6 people asking either for extensions on doing their continuing ed or asking about not doing it at all together. It was a problem, I'll be honest with you. It was every month the board met, there were a list to go through. So in discussions with the members of the board at that time, the board took a position, unless there's a very legitimate reason, then you should do your CE on time, and the board doesn't plan on making exemptions for people. The board does have the authority for good cause to exempt a licensee from continuing ed. Probably in the past 10 years, I can remember two individuals who the board has exempted, and they both have furnished doctors' letters to the effect. I'm sure this gentleman here would furnish a letter if asked to. There's some health issues there that I won't verbalize. That's the reason I wanted to ask you to read the letter. I mean, it's up to the board. Whether or not you. I feel like it's their responsibility in the office to bring it to you to make a decision, because he has written a letter to the members of the board, and he doesn't just verbalize it. He's asking for an exemption from CE, but that's really what he's doing. That's in what I think Ms. Mosby had spoken with him on the phone, and that's what he'd asked her about. He says other than his health issues, he has limited financial means.
Is he still working? Is he not working?
Turn two, if he's not able to do the CE, is he still able to? I mean,
For the duties.
perform the duties, yeah.
Do we know if he's planning on continuing to work, or is he just, hey, I've got this license, it's something I'm proud of, I'd like to keep it? I didn't.
I think the latter part, is that what you understood, Ms. Mosby, that
Yes, that's what he stated.
this will be the last time that he's required to do CE because of his age? Once the person has turned 65 under current law, they're no longer required to do CE. This licensee, whether he does a CE or whether the board exempts him, as long as he renews and meets whatever the requirements are to renew, then the next time it came up for renewal, there would be no CE.
This would be the very last one either way.
And when will they do?
It expires May the 31st. The license was issued, this might help you to make a decision. License was first issued on May 19, 2008, and it expires May the 31st. So that means in 2010, because the first time you renew, you're not required to do CE. So he did not do any CE in 2010. In 2012, he would have done 10 years of continuing CE. In 2014, he would have done an additional 10 years. So license has been issued, he's done CE twice.
Does he have any this time?
No, he doesn't.
Okay.
I mean, for me, if he were 40 years old and asking to be exempted from here on out, that might give me some concerns. He's done continuing education in the past. This would be the last time we would even be able to require it. That doesn't bother me as much, just to be honest.
Like Mark, I'm scared of opening a can of worms of exempting people. But with this being a one-time,
I'll just go ahead. I'll make a motion to exempt.
Motion by Mr. Cochran,
second that motion.
second by Mr. Helms. All in favor say aye.
Aye.
Is any opposed? Motion carries.
That's all I had under new business, Mr. President.
Ask for an adjournment.
So moved.
Second.
Helms, second by Mr. Ron. All in favor say aye.
Aye.